Welcome to Liberty Action Alert with Greg Seltz, sponsored by our friends at the Lutheran Center for Religious Liberty here in Washington, D.C. A program that cuts through the chaos and confusion in the culture today by talking to kingdom citizenship, bold biblical principles for a robust public Christian life. And now your host, Dr. Greg Seltz.
Good day, Washington, D.C., and friends of the program all across the country. I'm Greg Seltz. Welcome to Liberty Action Alert. Today on our program, we are talking about the Groff Supreme Court victory, and we have as our guest Mike Berry, General Counsel for the First Liberty Institute, and Tim Goeglein, Vice President of Government Communications, Focus on the Family. Welcome, Mike.
Great to be with you again.
Yeah, and welcome, Tim.
Thank you. It's great to be with you.
Okay, Mike, congratulations again for this victory in the Groff case. But to get our listeners, especially those who follow us, not just on radio, but also follow us on our webpage and stuff, what is this case really about? What are its implications? And what does this mean for the public practice of faith in the workplace?
Well, I'll start with the facts of the case, which are fairly straightforward, and then we'll get into the what does the case actually mean for the rest of us? The case involves Gerald Groff, who was for many years a happy mail carrier for the U.S. Postal Service in a rural part of Pennsylvania. And as most of us know, I think the three of us probably grew up in an era when the mail did not deliver on Sunday.
Right.
And that worked very well with Gerald because as a practicing Christian, he felt that it was very important to him in his faith that he observed the Sabbath, and he takes that very literally, meaning he does not do any work on Sunday. And as I just said, if you work for the post office, that would be a great arrangement because the post office for at least most of my life didn't deliver on Sunday. But around 2016, 2017, the post office entered into an agreement with Amazon to begin delivering Amazon packages on Sunday. So Gerald asked for a religious accommodation to not have to do that. And initially it was approved, but then there was a new management at his local post office. And the new manager, the new postmaster there, told Gerald that he was going to have to start delivering and working on Sundays, and that they were no longer going to accommodate him. Even if he tried to find, he tried to work things out, as you can imagine, offering to switch shifts with somebody,
right,
offering to take extra shifts, whatever he needed to do in order to make sure that he could have this religious accommodation, which is something that federal law permits. And so that's where really the legal issue arose, is federal law permits employees to seek religious accommodations. There is a law called the Civil Rights Act, and part of the Civil Rights Act is Title VII, and that governs, it prohibits unlawful discrimination in the workplace. And under Title VII, if you ask for a religious accommodation, the employer is typically supposed to approve the religious accommodation unless the employer can show that approving the religious accommodation would impose an undue hardship on the employer. And that's where the legal issue arose, because back around 50 years ago, in the early 1970s, roughly 50 years, there was a Supreme Court case called TWA versus Hardison. TWA stands for Trans World Airlines. I know the three of us.
It's gone.
The three of us are familiar with Trans World Airlines. Most of our younger viewers and listeners have probably never heard of it.
Well, a lot of people in St. Louis have heard of it because that was the key airlines in St. Louis. And when it left, it was hurt. Go ahead, Mike. Sorry.
Yeah, and so there was an employee whose last name was Hardison. And Mr. Hardison, just like Gerald Groff, was a Sabbath observant Christian. And he asked for the right to not have to work on Sunday. And TWA said, no, I'm sorry. And we're going to have you work on Sunday. And they used this exception that I just mentioned, this undue hardship exception. And the case went to the Supreme Court. And the question all the way back 50 years ago was, okay, so what did Congress mean when they talked about this undue hardship? Well, the Supreme Court back in the 70s is very, very different than it is today.
Right.
It was a much more progressive, I would even say, liberal Supreme Court who believed in, back then, what we would call a living constitution, right? I don't want to bore everybody with all the legal mumbo jumbo.
But let them know that, the idea that judges could actually create legislatively from the bench, where they could make up something, whereas they're supposed to just apply the law. Back to you.
So that was an era in which judges from the Supreme Court on down, by and large, would basically say, well, what do I think the result should be? Right. And whatever I believe the correct result is, because I'm a really smart person, I'm a judge. I went to law school. And so what do I believe in my wisdom and judgment is the right result? And then whatever I think the result should be, I'll just make sure that I write an opinion that makes the law match my desired outcome because I'm really smart, and obviously what I'm implying here is that a lot of times these judges believe that they were smarter than the rest of us. That was the decision in the TWA versus Hardison case, which was an undue hardship. What that really means is the employer just has to show that there would be more than a de minimis burden on the business. And so then people say, what's a de minimis burden? Well, de minimis is a fancy Latin word for, you can hear the root word minimus, which meaning minimum, right?
Yeah, it's inconvenience.
The bare minimum. If you can show as an employer the bare minimum of an inconvenience or a hardship on your business, then you win, employer. You don't have to approve the accommodation. Well, over the course of 50 years, you can imagine this became a one-way ratchet, right? To where the employer almost always won, where they could say, well, this is a more than de minimis burden on my employee in my employment. If I have to swap shifts with somebody, that's a burden. If I have to let somebody work overtime, that's a burden, and so on and so forth. Well, fast forward 50 years later to Gerald Groff's case, which went all the way to the U.S. Supreme Court, and First Liberty and our co-counsel, we argued that de minimis burden standard is not the appropriate standard. Right. It's not supported by the text of Title VII. It's not supported by the text of the Constitution. And thankfully, we now have a Supreme Court who no longer believes in this. Well, whatever we think the result should be, we'll sort of fire an arrow wherever it lands. We'll paint a target around it and say, we hit the target. Right. Whereas now we have a court and a majority on the court who look to the original meaning, the original public meaning of the words that are either in the Constitution or the words that are in federal law. And they say we have an obligation, whether we like the outcome or not, we have to give purpose and effect to the actual text. And that's what we mean by when we say a textualist court or a textualist judge or an originalist judge. Right. And that's what happened in the Groff case, is they said undue hardship doesn't mean bare minimum. Undue hardship means undue hardship, right? It's something that the business would not normally have to do in order to accommodate the employee. And so Gerald won. And so the court.
And what was the ruling? Was it a 9-0 ruling? Was it unanimous?
That was probably the big surprise in the case, right? Okay. Most people expected it to be 6-3, maybe even 5-4, and then it came out it was unanimous. Good, right? It was 9-0. Yeah. And in a religious liberty case, we haven't had many 9-0 decisions recently. Only a handful here and there. Right. So that was the big surprise that I think got everybody's attention. Wow. We even got the progressive justices to agree. And so what did they agree to?
Well, let me jump in to take off on something you were just talking about and talk to Tim about this, because I think underlying a lot of this is what Mike's talking about, which is this notion that the workplaces, the public realm, it's supposed to be secular. You bring in fact, what do we need to worship for anyway on Sunday? I mean, aren't we past all that? And kids are being taught this. They're even being taught that the revolution was really an economic revolution, that religious liberty had nothing to do with it. It's just so ridiculous. And then you see people who are serious believers, which undergirds our liberties, by the way, everybody. And somehow they're being attacked in the workplace. Don't we have to get the church people to at least start to understand that, we can't let that caricature of us be set into law, which is what was happening in this case. How is this going to challenge us as Christians, Tim? I think people are scared to be found out to be Christian today. They're not, blathering about their faith in the public realm. They're just afraid they'll be found out and fired. And how is that going to maybe turn this around?
Yeah, I'm celebrating de minimis progressivism. I think we need this. I think we need the smallest amount possible. So let me take a step back and take a crack at this wonderful question you've asked. Does anybody, left or right, find it, what they say in England, passing strange, that this remarkable Groff case arose in a state, in a commonwealth, named for one of the greatest defenders of religious liberty in the history of the United States, William Penn, where the named, of course, Pennsylvania takes his name from where the Groff case arises. William Penn wrote at length some of the most powerful treatises on religious liberty and the rights of conscience in the history of our nation. And I was reading some of those actually this morning in preparation for our conversations together. I'm really struck by the timelessness of what Penn was saying. Right. And he was speaking very specifically about the kind of coercive actions that increasingly both the private and the public sector think that they can kind of ipso facto employ for their own ends. There's nobody really east to west in our great country who thinks that somehow the United States Postal Service cannot accommodate a Christian who's living in the rural part of Commonwealth, Pennsylvania, because this man wants to take a day for his Sabbath. And I want to say a second thing, if I may, Greg, to the other point that you raised. And I think it's very important in light of this great victory for our friends at First Liberty Institute. And by the way, it is a great victory. Right. And it's the following. I think for all the rightful concern and prudence over the so-called Roberts Court, I think that this perhaps might be the most pro-religious liberty Supreme Court that we have had in American history. And I actually include the great Chief Justice Marshall, in that. Think of the sheer number of religious liberty cases that have come to the United States Supreme Court, many of them Lutheran in derivation. I mean, just since the time that John Roberts became our Chief Justice. And I think that these great victories, not that we do, but they just cannot be taken for granted. These are very big wins.
Well, and let me get back to you, Mike, because this is my thing. You guys are doing great in terms of the court. Even when I talked to Kelly Shackelford, he said, the courts are blowing the jail cell open, but Christians are still stuck kind of in this notion that I don't have the freedom to kind of go out there and be Christian. We're literally keeping ourselves out of the conversation for fear of it still, costing us something that we can't afford to pay. And I guess my challenge now is I see what you're doing. You're doing a great job, and good thing this was a 9-0 ruling. But on some of these other cases too, right away, the folks who are what I call secular pietists, they're not progressing to a utopian goal. I think they're regressing from kind of the freedoms that we have. They're already doubling down. They're smearing the court. They're still smearing believers as if we're the ones causing these problems if we would just get on board. And so I guess my challenge to you now is, as a lawyer who's learned how to actually present these cases properly, help our people in kind of voicing what this is really all about. We're the ones that are the live and let live people in a lot of these issues, but we still want to be able to be who we are because we believe it's a blessing to others. How did this stuff get turned around?
Well, and you brought up so much there to unpack, right? I mean,
yeah.
I'll start with something you said towards the beginning of your question, which was talking about, as believers, when we get these victories, you said, Kelly Shackelford, our president and CEO at First Liberty, says it's like the court are throwing open the jailhouse doors, but yet many people of faith in this country are sort of still stuck in their cells and don't realize it. And I think there are actually a lot of theological parallels to that in terms of what it's like as a person of faith, and specifically if you're a Christian, that often we are given freedom, right, by our Lord and Savior, and freedom from bondage to many of the things that weigh us down in life, and yet it's as if we don't realize that we've been freed from those things, and we continue to just allow them to affect us. And so I think there are definitely some theological parallels there. But further,
well, listen, you just said something. I got to jump in because that was, man, you're Mike, you were Lutheran there, my friend. I mean, my goodness. No, I mean, the idea that the Christianity is not a religion. It's a declaration. It's a declaration that you have been freed. Somebody freed you and it had nothing to do with you. And now you can live in that freedom, or you can stay in the bondage that you've decided to stay in. And that ultimately is the message. Religion is do something to get God off your back. Christianity is the proclamation that God got himself off your back. But anyway, what you're saying now, back to living this, well, we've been kind of browbeaten that we're the problem and we should self-mute so that, we don't affect society in a negative way. I would argue if you get out there and just act Christian and act the way that God gives you to act, you can be a real blessing even to those who don't necessarily agree with you on these issues, right?
Yeah, I mean, you brought up a lot of the critiques and even the attacks on the court, its legitimacy, the justices themselves. And, I find that as a student of the law, as a student of history, I find that to be just so interesting, because if you go back to that era that we were talking about, right, in the 70s and 80s, when the court was far more progressive and it was delivering victory after victory for the far left in this country, and it was conservatives who were crying foul, right? It was conservatives back in that era who were criticizing the court as being an activist court, as legislating from the bench, as departing from the Constitution as the framers intended it to be. And the far left were the ones who were defending the court and its supposed legitimacy back then, and calling for judicial independence and saying that conservatives shouldn't be criticizing the court. Courts should be free from that sort of criticism and interference with the ability of those judges to do their jobs. And yet now that the composition of the court has shifted and it's beginning to deliver some conservative victories, you see that their tune has changed. So what this is really about, and I hate to be dour about it, but it's about power and control. They ultimately want power. And when they have power, they'll do anything they can to keep it. All right. And when they feel that power is beginning to slip from their hands, they want to change the rules. It's like Lucy with the football and Charlie Brown, and they want the ability to continue to hold that football. And every time, we think that this was back when we had a liberal Supreme Court, or one that delivered victories to the liberals on a consistent basis. Defeat was snatched from the jaws of victory time and time again. And now that the tide is turning, you're seeing that they say, well, now we need to change the rules. Right. We need to. You're hearing from the far left and the extremists. We need to expand the Supreme Court. We need to give President Biden, or whomever it happens to be, all right, that the opportunity to fill the court with as many justices as we can. But watch, if I don't know, obviously I can't read the future, but if a Republican happens to win the White House in the upcoming election and has the opportunity, and a Republican has the opportunity to appoint judges to the federal bench, just watch how fast their tune changes. And and how fast, you mark my words, they will so quickly say, we don't need any more justices on the Supreme Court. We don't need any more. We need to stop the flow of lower court judges, and so on and so forth. So that just should tell you, it's never about principle. It's only about power.
Well, and one of the things I want to say to people out there, because I hear this all the time, well, we're a conservative court. No, we want a liberal court. No, even when the conservative court, as they're titled now, it's a constitutional court. That's different than a conservative court. My conservative politics might not win on some of these. There was just another ruling that I didn't agree with. I thought, the court got it wrong. But again, you didn't see conservatives marching on judges' homes. You didn't see conservatives threatening judges or the judiciary. You didn't see them trying to knuckle it under, because the founding fathers understood that there was going to be selfishness in every branch of government. They knew that, which is why they kept them separate. Folks, quit falling into this notion that whoever gets the court, they get to get their politics through the court. No, there's one group of people saying the court's not supposed to be political. It's supposed to obey the law, or it's supposed to limit these people by virtue of the constitutional limitations.
One thing on that, and because I believe it was Justice Thomas, I'm pretty sure it was Justice Thomas who once said that the mark of a good judge is that he will sometimes reach a decision that he personally doesn't like. Okay. But yet, nevertheless, that is what the law, the text of the law, compels him to reach as a decision, even if he personally doesn't like the outcome. And he said that's the mark of a good judge. And I absolutely agree with that 100%. And I wish every judge in America were like that.
Boy, that's a phenomenal statement right there, because disagree with that. Okay. And I don't care what side of the argument you're on. Okay. But here, Tim, lately, what now is coming our way in terms of us defending some of these things. Now I'm hearing things like abortion. We demand abortion because it's our religious perspective. It's for religious liberty perspectives that we demand this now. And I can almost see Festivus now being, demanded as a holiday to be celebrated when a guy wants to get off work. I mean, I can see some of the silliness of this going. We think that's ridiculous. But when you can claim religious liberty to kill a baby, it's just, it blows our mind. Christians need to be aware of that. And I've had some Christians ask me, well, what do we do about their saying that this is a religious liberty issue for us? So there's a sense where we're going to have to defend what religion is again in the public square too, right. Don't you think?
I do. I think it's very important that we send up a signal to our fellow believers that we are in an era of both distraction and an era of manipulation, especially when it comes to the United States Supreme Court. And this is why going into the third turn, I guess, we're in the middle part of the year into 2024, why the stakes are so high. Clarence Thomas, 75 years old. If he serves on the court 5 more years, he will be the longest serving justice in the history of the United States. This October, he will be on the court 32 years. Justice Alito, a very reliable constitutionalist, well into his 70s. We talked about Chief Justice Roberts nearing that 7th decade. We know that the last president, before President Biden, President Trump, confirmed over 200 federal judges and 3 members of the United States Supreme Court. To the second point, we are a year past Dobbs, and we have a member of the Supreme Court, Justice Alito, who says he knows who leaked the draft. Back to manipulation. And it just seems to me that in the era that we're in, and to Mike's point as well, and I know First Liberty Institute has done this phenomenal work on what they call the Supreme Coup, artificially expanding the size and scope of the Supreme Court on the part of progressives so that they can more predictably get the outcomes they want, even though it may not be what the fixed meaning of the words of the Constitution say is permissible, is lawful. So it just seems to me that as we look ahead, just a few months down the line, we have a huge stake as believers in this whole question of what is the future of religious liberty, as attenuated by the men and women who may be next on the Supreme Court and next in the federal courts.
And so I'll just end it with this. Folks, doing what is right in your own eyes is not a religious principle. There is going to be this falderall and just turning this stuff on its head to see if that works. We have to begin to realize that the law, the way that God orders the world in the scripture, when that was taken seriously in public policy and organizing, both the government and the freedoms that we have, it set free individuals unlike any other time in human history. And there's a reason for that. Your rights come from the fact that you're created by God. All that stuff is worth defending. Your liberties of even other people who don't believe it depend on it. So we need to get back involved in this robust debate, not only of temporal freedom, which is July 4th and all the stuff we've just celebrated, but also about the eternal freedoms in Christ. And Mike's work has given us, again, more freedom to do just that. And Tim, you and I are going to have to actually continue to help our people be robust proclaimers of that for the sake of everybody. Mike, thanks again. Keep up the good work. Let people know your website just so they can go and take a peek at all this stuff.
Firstliberty.org.
And thanks for being here, Mike.
Thanks for having me.
All right, Tim, and thanks again. We'll continue to talk about these victories.
Thanks so much. God bless.
Thanks for tuning in today. To get to know our LCRL-DC work better, check out our website at lcrlfreedom.org. Contained there are resources to empower your public square dynamic discipleship. or check out our weekly Word from the Center opinion piece every Friday at facebook.com/LCRL Freedom. Till next time, God bless you always. I'm Greg Seltz. Have a great week.
You've been listening to Liberty Action Alert with Greg Seltz, Executive Director of the Lutheran Center for Religious Liberty in Washington, D.C. This program has been brought to you by the Lutheran Center for Religious Liberty.